the AAJLJ program. Good afternoon, everybody. On behalf of the AAJLJ, we'd like to welcome you to our program today, Litigating UNRWA, a legal assault on the infrastructure of terror behind a UN flag, with Richard Heideman and Joseph Tipograph of Heideman, Noodleman, and Calic. Richard and Joseph are longtime friends, collaborators of the AJLJ. So thank you so much to both of you for joining us today. We appreciate you and all of the amazing work that you're doing right now and are happy to spotlight it today. So today we're going to discuss a lawsuit that the firm has brought on behalf of American victims of terrorism, seeking to hold UNRWA and the American charitable arm of UNRWA accountable for knowingly enabling Hamas and other terrorist organizations. Most of us know a good deal about UNRWA and their actions and their enabling of terrorism. So in this discussion, we're going to explore how the plaintiffs are using the U.S. anti-terror laws to hold UNRWA accountable and confronting the legal and political protections afforded to UN agencies and how they're seeking to prevent successor entities from continuing UNRWA's deadly mandate. Richard is a highly acclaimed attorney, many of you know, and you can read his bio if you are willing, but he has very impressive work and continues to do so much for the Jewish community. And Rhonda Lees here has a copy of his book. She's not here, but it's called The Bloody Price of Freedom. And thank you so much to Richard, as always, for joining us. And we also have Joe Tipograph. He also brings his really important work on behalf of victims of terror and their families by analyzing and presenting damages evidence in federal court litigation. Richard and Joe, together with other members of the firm, work to advance the rights of their clients and to seek justice under the motto that we all prescribe to, justice, thou shalt pursue. And I am going to hand into Rhonda Lees, one of our vice presidents, is going to be moderating this conversation. And so I'm going to hand it off to Richard and Joe to get started and to let you know about the really important and unique lawsuit that they've brought.
Thank you, Joe. Go ahead.
Thank you, Alyssa. Thank you, Rhonda, and thank you both and all of you at AAJLJ for the incredibly important and wonderful work that you all do. I've been participating in the programming for many years now, and I'm honored to now be presenting here. As a law firm that represents American victims of terrorism, UNRWA has always, even prior to October 7th, been in our crosshairs. Rhonda showed The Bloody Price of Freedom. Richard and I worked on that book together, and you'll see a whole chapter dedicated to UNRWA and really unpacking the critical role that UNRWA has played, not only in promoting terrorism, which is the subject of this presentation, but it has really gotten in the way of peace, and it has also prevented, in our view, the Palestinian population from ever achieving a better way of living. And all of this kind of culminates together and leads to the results that we've seen here on October 7th. I'm coming to you from Tel Aviv, where I've moved with my family to work directly with our clients of October 7th. And it's on their behalf and on behalf of other clients of ours who were killed and injured prior to October 7th, who we brought this lawsuit. It was many years in the making, and we think it's an incredibly important one. So the UNRWA case we brought under the Anti-Terrorism Act and JASTA against UNRWA and UNRWA USA. The Anti-Terrorism Act is the law that usually applies to non-governmental agencies, sponsors of terror, non-state sponsors of terror, and state sponsors of terror, such as Iran and Syria, and in our case, North Korea. We've also brought a case on behalf of our clients against all three of those countries. Those cases are filed under the FSIA terrorism exception. That isn't the subject of this discussion. We're talking about the Anti-Terrorism Act, and it's an important one because it's an area of the law that has undergone some major change, that has experienced a major precedent in the last few years, including in this space, and we'll talk about that today. And in order to make this case about the material support that UNRWA provides to Hamas, when you really lay it out on the table, it is overwhelming. It's not just funding like you might see from a bank, but there's infrastructure, there's indoctrination, and there's so much more, and we will get into it. And there's a unique aspect to this case against UNRWA that you don't see against banks and charities, which is that under the flag of the UN, UNRWA has already, in a related case against it, relating to October 7th victims that have been filed, not our case, but they have already made clear that they are asserting that they should be immune from lawsuit as a UN entity. And that's going to be something that we'll talk about as well today. The first thing I want to talk about is proving liability under the ATA. This is something that is a very, very important issue when it comes to representing victims of terrorism against non-state sponsors. It's become pretty challenging in the last few years. The test that you can see on the left is the Halberstam versus Welsh factors. These are the things that the courts will look at when they determine whether a defendant has provided material support and whether it qualifies, whether it meets the test. And in 2023, if you look in the middle, the Tomney versus Twitter decision has been one that all of the plaintiff lawyers who represent victims of terror in cases under the ATA have been forced to reckon with. It was a case that was perhaps brought out of good intentions, but the results of it have been very challenging because when the judge in that case ruled for the defendant and found no liability, they laid out certain new standards about what qualifies as substantial assistance. And those standards have been applied in cases that have come out since, including October 7th cases. And the results of that have not been good. We see this as a case that has the potential to really push the law back in a very positive direction because of what we believe to be an overwhelming record of support for terrorism that is provided by UNRWA and by UNRWA USA. Effectively, what the decision said is that it's not just enough that somebody provides support to a terror organization. It has to relate to a specific terrorist attack. And if you look on the far right, the Lavi versus UNRWA USA case, that is not our case. It's a case that one of our good friends has brought, but unfortunately was dismissed a few weeks ago. The point that the judge made was that because the complaint does not specifically say that UNRWA USA was aware of UNRWA's connection to Hamas, that the plaintiffs could not plausibly argue that the defendant, UNRWA USA, had notice or inside knowledge regarding claims that would not become public until after October 7th. And that language suggests that a defendant had to have been in on the plans for October 7th. And, we, of course, disagree with this holding. And we think this case, and by bringing this case not just against UNRWA USA, which is a US 501(c)(3) organization, which allows us to get jurisdiction over them, but by bringing it together with a case against UNRWA, it allows us to tell the full picture and tell the whole story and really show the integration that exists from Hamas and the other terrorist organizations to UNRWA USA, and the degree of information that was in the public domain. As I mentioned before, we've been thinking about this case long before October 7th. There is really no excuse that anybody could not have known that the support that was being provided over the years is going to lead to an October 7th. So what am I talking about here? UNRWA has done so much to allow Hamas to do what it does. It almost is it's almost never properly captured, even by the media that supports our views. Okay. This is not a situation, in my view, this is me speaking personally, Richard will share his as well, where Hamas has hijacked UNRWA or has taken advantage of UNRWA to use resources to commit acts of terror. In my view, and this is a view that we express, I think, very clearly in the complaint, and then this is, of course, supported by extensive information in the complaint, which I believe Rhonda will be sharing in the chat group if she hasn't already. That this is a case where UNRWA's really laid the groundwork for Hamas to exist, for the whole terrorism regime that exists in Gaza and the West Bank to exist. It starts when UNRWA's teachers union specifically played an instrumental role in helping Hamas seize power in the 2006 elections. UNRWA's leadership coordinates with terrorist organizations, but it does more than that. It publicly goes to bat for them. It sees itself as there not being a problem with its integration with Hamas. And there have been many moments in history over the last several decades where leaders of UNRWA have made comments that show just how insensitive they are to the damage and the danger and the murderous, maiming conduct that Hamas engages in. On top of legitimizing UNRWA, Hamas, UNRWA provides funding where other areas that UNRWA operates, they'll operate and they'll pay teachers in the local currency. In Gaza, in the West Bank, they don't pay in Israeli shekels, which is the prevailing currency. Instead, they pay in US dollars. And one of the things we point out is that when you pay in US dollars, the exchanged money benefits Hamas, which owns all of the money changers. And they know that. And that is an incredible source of income, in addition to other funding that goes to UNRWA that finds its way ultimately in the hands of Hamas. I don't have to tell anybody here about the use of the UNRWA schools and facilities that have been uncovered, it seems like, on a constant flow of information, storing weapons, building tunnels, command centers, holding hostages, sources of electricity, and so much more that goes on in these schools. And it's not just the physical aspect of these schools and facilities. In the classroom itself, I don't have to tell you all about the incitement, the hatred, the erasure of Jewish identity in Israel that gives rise to this belief amongst such a large swath of the Palestinian population that they are entitled under the banner of the United Nations, which UNRWA purports itself and holds itself out to be, that they have the right to Israel. And they have the right to return to Israel, and that they have the right to return to Israel by force of arms. So this is what we're talking about, and this is so much more than money. Again, I don't have to tell anybody about the implication of the UNRWA employees. We've all seen the news. We've all heard about the dozens who participated in the October 7th attacks and the hundreds who are affiliated with members or members themselves of terrorist organizations, hundreds, if not thousands. And, you know, Hamas has control over the teachers' unions. And at the bedrock, it's the last point here on this slide, but it might be the most important, is the perpetuation of generational refugee status. Um, I'm sure I don't have to tell anybody here about comparing and contrasting UNHCR, which is what defines refugees in the entire world, except as it relates to the Palestinian refugees, and UNRWA. And these two are not just different in who they cover. It's about how a refugee leaves refugee status and how and whether the children of refugees maintain refugee status. That is something that is true for UNRWA. That is not something that is true for UNHCR. And the effects of these two differing refugee policies are evident in the lives that are lived by those who are covered by them. People who leave a place anywhere else in the world out of fear for their life and their safety are able to build a new future for their family, are able to move forward with a new country of citizenship that future generations will make their own. And it allows them to move forward and work towards a life full of dignity and prosperity, where UNRWA's perpetuation of generational refugee status creates a whole grievance structure, as it creates a demographical powder keg, if you will, that surrounds Israel's borders. And it's only growing. It only grows in size, where other refugees, they get checked off the list once they've resettled and built a new life. In the case of UNRWA, the Palestinian population grows and continues to grow in the face of frivolous accusations of a genocide. And it's an incubator. All of this is an incubator of the terrorist mentality that Hamas and the other terrorist organizations are able to feed off of, and and in so doing have been able to perpetrate attacks like the tragic October 7th massacre, and so many more that continue to this day. UNRWA USA has its own rule. UNRWA USA is the fundraising arm of UNRWA in the US. But it's not a distinct charity in the sense that it has no relation at all to UNRWA. In fact, for a very long time, up until recently, UNRWA itself on UNRWA's website would have a donate button. And when you click on that donate button, it would forward you to UNRWA USA. There is an integration between UNRWA and UNRWA USA that cannot be denied. And UNRWA USA raises lots of money, millions of dollars in the United States, most notably around its Gaza 5K runs. And anytime UNRWA comes under scrutiny, UNRWA USA is one of the first to speak out in support of UNRWA, showing no regard for the damage that Hamas causes and UNRWA's role in supporting it. So we talked before about the issue of liability. A secondary issue that's, but just as important, is one of immunity. Okay, under the CPIUN, which is the Convention on the Privileges and Immunities of the United Nations, the UN itself is immune and enjoys something that it refers to, and US courts have referred to, as absolute immunity. And that has been exactly what it sounds like. There is not much, if any, case law out there showing examples of somebody successfully suing a UN affiliated organization and being able to survive the immunity challenge. And feeding off of that, UNRWA, upon being sued not by us, but by in a related lawsuit by another firm, um, they immediately raised the challenge of the defense of immunity. And the United Nations wrote to the United States government and said, please do what we expect you to do, which is to inform your courts that this lawsuit cannot be brought because we are immune under your laws. And on July 30th, 2024, the Biden DOJ filed a statement of interest in that case. Their argument is fairly simplistic. It really boils down to the United Nations General Assembly created UNRWA, and therefore, and the United Nations General Assembly refers to UNRWA as a subsidiary organ. That is sort of the magic language and the legal tests that courts have applied to determine whether an entity enjoys the UN's immunity. And based on those 2 points alone, the Biden Justice Department told the court that despite the horrors of October 7th, we take the position that UNRWA and UNRWA should not face lawsuit in America. We, even though this was not our case, we filed an amicus brief in that case on behalf of several organizations, including Stand With Us, and the National Jewish Advocacy Center and several others, arguing many of the points that we make in our own case, in our own complaint, and that we will be arguing in our own case. And before any decision was made on that, there was a change in the administration. And almost immediately, very shortly after the Trump administration took office, they filed a letter in the proceedings saying, we are reconsidering the position that we took. And on April 24th of this year, they filed a reversal letter with the court. They said, we understand that the Department of Justice has previously said that we believe UNRWA enjoys immunity. We are no longer taking that position. And they really went after the arguments that the Biden Justice Department advanced in their statement of interest, and the ones that which follow tracking the points that we made in the amicus brief that we had filed. And I think the heart of the argument, there's a lot of technical aspects to the DOJ's position about the formalities that need to be undertaken in the United States for an agency such as UNRWA to be designated as something that enjoys immunity, and those technical requirements were not met. But above and beyond that, I think the core and the most important aspect of their letter, and this is me speaking for myself, was this point that no entity can transfer more than he owns. Nemo dat qui non habet. My Latin's terrible, so I apologize if I butchered that. But the point they made is that the functions and powers of the General Assembly, as set out in the UN Charter, Articles 10 through 17, do not include anything that approaches the direct administration of a comprehensive economic, social, infrastructural, educational, and public works regime of the sort that is operated by UNRWA. And if you look at that list, the economic, social, infrastructural, educational, and public work, every single one of those elements of what UNRWA does factors in to the support that it provides to Hamas, and does so extensively. So those are the arguments, the liability and the immunity. Those are going to be the arguments we will be taking on in this case. We think this is such an important case. We think it's essential to challenge this idea that the UN's immunity is somehow limitless, and that the General Assembly can somehow enact organizations to do all sorts of things that can then enjoy its protection. without any U.S. oversight or accountability towards the United States citizens that may be harmed. And in this case, of course, that's extensive in the context of October 7th. We also want to establish accountability for organizations funding terror after the Twitter decision, the Tomney versus Twitter decision. We think that the extensive record of support that has been provided by UNRWA to Hamas and the terrorist organizations that goes well beyond funding. It goes to indoctrination, and it goes to the whole mentality and the whole perpetual refugee grievances that give rise to the terrorist mentality. All of that needs to be viewed through the lens of the ATA, and to establish a baseline for accountability for these organizations, because the law has gone way too far in favor of defendants in these ATA cases, and it needs to be brought in, and we believe this is the case to do it. As we of course want to further expose the complicity that exists under the UN banner, and everybody, and I don't have to tell anybody who's here on this program, but certainly the further along we can bring this case, the more success we can have. It is our hope and is our expectation, it is our plan to make sure that the world becomes more and more aware of what entities that are associated with the UN, even when they're not subsidiary organizations, as is the case with UNRWA, just how far that they can go waving that UN flag, and that it doesn't mean that the UN flag isn't some sort of symbol of unity that so many out there make out the UN to be. And of course, this case is squarely within our values of our law firm, in the broad defense that we provide to Israel against diplomatic attacks and lawfare. Our firm has been involved in matters before the ICC and the ICJ. We have filed briefs on behalf of various organizations in all of the major matters that have been brought. And we continue to work very hard on those things, even though the cards are stacked against Israel, it seems. In every single case, we believe that somebody has to stand up and say something, and that's what we're doing. And here in this case, as you can see with issues such as immunity and the unfortunate rulings that have happened in ATA cases, many firms might be dissuaded from investing in a case like this, but for us, it was never a question. It was never a question that this was a case that needed to be brought, that this is an injustice that exists and one that needs to be confronted. So with that, I'm going to turn it over to my colleague, Richard Heideman, who is one of the forefathers of anti-terrorism litigation. He is my personal mentor and friend, and someone who has done so much remarkable work in this space and achieved so much and worked so hard for Israel and the Jewish global community. Richard?
Joe, thank you very much for that excellent presentation. I'd like to cover a few things to put in context, high points as well as details that Joe outlined. First of all, he mentioned clearly, and I want to be sure you all understand, that there are three prongs, let's say, of bringing cases on behalf of victims of terror. First of all, against a state sponsor of terror under the terrorism exception of the Foreign Sovereign Immunities Act. You can only sue a country that is on the State Department list of state sponsors of terror for an act of international terrorism. However, the law has been broadened so that if that act of terror occurred in the United States, such as the tragedy of 9/11, then you can bring an action, and that case is going on against Saudi Arabia and others up in New York arising out of 9/11. Just wanted to make sure you understood that first prong. Secondly, under both the ATA and JASTA, there is this whole body of law that now statutorily permitted actions are being brought not only for direct liability, but for aiding and abetting. These are federal causes of action. So if there's an American national who has been killed or injured, they have a claim, as do their near family members who are Americans, mothers, fathers, sisters, brothers, spouses, and children. One interesting factor about the cases brought under the Anti-Terrorism Act is that while under the Foreign Sovereign Immunities Act, the courts have been awarding punitive damages against Iran and Syria, for example. And the most recent case that we have handled, I think the court used a multiplier of 3.44 times the compensatory damages. But in the ATA, you do not get punitive damages. In the ATA, you get treble damages. And then interestingly, you also have the entitlement, of course, to costs, but moreover, to an award of attorney's fees. We have a case, not an UNRWA matter, but I want to put it in context for you, where there was a Taliban attack on hotels. Americans were killed in Afghanistan, and we sued. And we sued for the state sponsors of Taliban. After getting the judgment, and in thinking about how we might be able to recover for our clients other than by putting them in the victims fund, we did some research and found that actually some other law firms had sued the Taliban. We went back to the court where we got our FSIA judgment, filed an ATA action because the Taliban is not a government, even though they control the Afghanistan government, shall we say. They took it over. And we now have a judgment against the Taliban. We served them by publication. We went through all the steps, got them served, issued the necessary opinions to the court upon which it could grant the opinion. And now the court has come back to us and said, please file by X date in October your application for attorney's fees with briefing. Whether we'll ever be able to collect against the Taliban as compared to a government under the FSIA, another story. But it's a matter of taking an approach under the ATA. I want to cover another ATA case because it's a set of cases because it's relevant. The PA and the PLO. We sued them on behalf of the Kleiman family, who lost their daughter, Oliver Sholem, in the second intifada. She was killed by a bullet that went through an Egged bus window. We've been in that case now for 22 years, the Kleiman case. In another case, and this is an ATA matter, in another case, our friend Kent Yalowitz of Arnold and Porter up in New York filed against the PA and the PLO. His case under the ATA went to trial, and the ATA is important because this UNRWA action is under the ATA. UNRWA is not a government. They don't have FSIA protection. UNRWA USA, as Joe explained, is a charity. Let me finish this PA-PLO matter because it's current, and you all should be learning about it and thinking about it and taking action on behalf of your clients. The PA and the PLO fought the Kent Yalowitz filed case, the Sokolow case. It's also known by Waldman. He went to jury trial, got a $200 and some million verdict. That verdict was trebled. He ends up with a $600 and some million verdict. And then the verdict is vacated based upon a motion of the PA and PLO alleging that the US courts don't have jurisdiction over the PA and the PLO. Congress has worked to fix that. It went all the way to the Supreme Court in a case where another law firm that we work with brought it in the matter of Fuld versus PA-PLO. And just this past term, the court determined that you can sue the PA and the PLO in US district courts if they meet the specific indicia set out by the statute. I won't go into the details other than to tell you the ATA, and JASTA, which have many challenges from courts all over the country, and where the judges, in our view, are not following the intent of Congress to give access to U.S. victims to the court system for redress, for justice, for accountability. Many judges, most judges, have been throwing cases out. A case that wasn't thrown out was, as you know, the Arab Bank case, which was filed as a result of the Second Intifada. That case was settled, and that was an ATA case after a jury trial where it was determined that Arab Bank was liable under the liability theories put forth with the evidence that was put forth of their funding of Hamas on behalf of a client of theirs called the Saudi Committee to Support the Intifada. I won't go into the details. We've also covered it in other symposia with AAJLJ. But what happened is that case ended up not only getting a recovery for those families, but an appeal was allowed to be taken as part of the settlement negotiations, and the original judgment, the original verdict, shall we say, on liability was vacated on instructions. Yet the settlement went through because of the way that it was negotiated. The clients were able to recover under the settlement. Let's move back to UNRWA. As Joe explained, there is a necessity to compare and contrast UNHCR and UNRWA. I'll do it in a sentence. UNHCR, the UN High Commissioner for Refugees, is responsible at the UN for refugees all over the world. The only exception to those refugees being resettled, given benefits, given clothes, given travel, given stipends, given food, given new homes. The only exception are those who are within what's generically referred to as the Palestinian territories. The UN set up UNRWA, UN Relief Works Agency. It has, under UN policy, exclusive jurisdiction. It doesn't resettle. In fact, it opposes resettlement. It keeps people into camps. It keeps people into what I prefer to call ghettos. For the UN to have done so for all these years is unconscionable. And what they do to these people is they indoctrinate them, as Joe said. They teach hate in the schools. They use a curriculum that is beyond comprehension. In our years, decades of fighting terror finance cases, as Joe indicated, we took a look at UNRWA long ago, feeling they should be held accountable. And as a result of believing that, we had designed and were planning to bring a case before October 7th. But October 7th is a turning point for us and for everybody else because we're all tired. Let's face it. You fund these cases and you hope you can get through a judge's motion to dismiss. You hope you can get through to a settlement. The other law firms, biggest law firms in the country, are representing the defendants in these terror cases, and they're throwing out jurisdictional issues as well as the issue of, shall we say, knowing accountability. But understanding the failure of UNRWA is also understanding that under US law, the courts ought to permit us to go forward. The first UNRWA case that was filed that Joe mentioned was up in New York. It was filed by friends of ours who only sued on behalf of non-Americans. They didn't sue under the ATA. They sued under the ATS, Alien Tort Statute. That's the case in which the Biden administration filed a statement of interest, now superseded by the Trump administration. And we're waiting for the court to rule up there on that immunity question that has been raised in the ATS case. Our case has been filed in federal court in DC. We will potentially have a split of the circuits, but nobody can tell us or you or anybody how the immunity issue will go, how the knowledge issue will go, how other indicia will go, because cases that are being decided, as I'm going to repeat for the last time, are being decided adverse to plaintiffs, victims, families, all over the country. It needs a legislative fix. We're working with other law firms on that. Can't be done alone. Can't be done alone. It needs all of us to do it. UNRWA's pattern of complicity is longstanding and bipartisan acknowledged. And when one looks at October 7th and the heinous barbaric conduct of Hamas, PIDG, PFLP, supported by UNRWA, actively supported by UNRWA, one understands the need to seek legal accountability and justice. In one of our cases, we've also sued as a result of Hezbollah attacks from the north that started after October 8th. And the Hezbollah victims are also in our UNRWA case because there are UNRWA schools up there as well. I want to conclude with this. We have adopted a zero tolerance approach toward and against those who support, fund, and encourage terror, anti-Semitism, boycotts, demonization, and discrimination. We think that all of the firms are playing important roles. The nonprofits, whether it's the Lawfare Project, the Brandeis Center, Stand With Us, ZOA's center, and others that are bringing lawsuits, they deserve support. They need pro bono support. They need financial support. They need encouragement because these cases all have to be brought. I want to conclude by telling you there are broad implications. One has to look also at the court of public opinion because those who hate us are busy using the court of public opinion to radicalize, to indoctrinate, to teach hatred, and to make it appear as though it's okay, as if this were again the 1930s. It's okay to target Jews because we're Jews. It's okay to target Israel because it's the Jewish state. Well, guess what? It's not. And every one of your firms and our firm and the other firms we work with, and thank God we have excellent relations with almost every one of them. We've worked with them for decades. We respect and appreciate them. All of us together need to work to try to make a difference, to seek justice and accountability. Thank you for participating with us today. We'll be glad to answer questions in the 12 minutes that we have before we need to recess. And I'll turn it back to Rhonda. Thank you.
First of all, thank you very much. And for those who did not see, if I can get this correct, this is a copy of Richard's book, The Bloody Price of Freedom. I have been getting some questions, which I will take. I'm using moderator's privilege just for a minute. I'm only on section 215 of the brief. But in terms of what's easier, given the fact that UNRWA USA is a 501c3, which means the IRS gets involved, what would be involved if someone were to sue them directly? Not UN, I mean, because there is no statutory reason not to sue, simply UNRWA USA. What is involved with that? Is that an easier fix? Is that a harder one? Would they give you the answer of, no, we're not really a C3, we're simply the UN, and then you have a lot of your answers? So any thoughts about that?
We have actually sued UNRWA USA directly. They are a named defendant in this action. Joe?
So that's a great question, Rhonda. And the Lavi versus UNRWA USA case was decided weeks ago.
Okay.
And it didn't go in the direction we would have liked to see it go. I think that while, the immunity argument didn't surface in the UNRWA USA case, they, by not suing UNRWA USA and excuse me, and UNRWA together, I think that they created a gap in the chain, and that gap in the chain was UNRWA. And so you had on one side, you had UNRWA USA, on the other side, you had Hamas, and then in the middle, you had UNRWA. And it's sort of, in my view, when I read the case and I read the decision, it came across almost as like the empty chair that the court was able to point to, and the where so much of the allegations had to go through. By suing them both together, we think that we've roped them all in together and we tell one cohesive story. So is one easier than the next? These are both hard cases to bring.
I'm sure.
Both
I'm
be
sure.
hard cases to win. But we are committed to doing everything we can to come out on top here.
And to make it clear, there are about 200 plaintiffs, some represented only by our firm and others jointly with other firms with whom we cooperate. And some of those firms wanted their names listed on the pleadings. They're there. Others didn't. But collaboration, corroboration with different firms. When I say corroboration, I mean everybody has ideas and you want to share those ideas to come up with the best way to do these cases. And we think it's essential to have cooperation among firms. Whether or not, by the way, somebody on behalf of the defendants will seek to try to consolidate or transfer cases that are up in New York with here, with elsewhere, this will also have to see. Back to you, Rhonda.
Well, first of all, thank you. I didn't give a long enough thank you, but thank you very much for this. I mean, I've been in touch with both of you for a while, and waiting for this to be filed was a big deal. We were so excited to hear, and we wish you absolutely the best of luck. Just to let you know that AAJLJ had filed an amicus brief in the Fold case. So it is an issue that we have participated in for some time. I see a couple
of Rhonda, just so that it's clear and for disclosure, our friend Sam Silverman, a lawyer we work with up in New York, filed the Fold case along with Jeffrey Fleischman, we work with him as well, up in federal court in New York. They lost because it was against the PAPLO. They took it to the Supreme Court. We followed it. We were talking with them. Now that they have won it, it's back at the Second Circuit, waiting for it to come back to the Southern District. 2 days ago, we filed for the other half of the Fold family that we represent, a related action for those family, for the remainder of the family that we represent. We filed in the Southern District a related action. We will now cooperatively work with them, await it coming back from the Second Circuit. Hopefully, we'll get it to a jury trial in New York. The Kleiman case that I mentioned that is 20-some years old that we've been working on against the PA and the PLO is now back before the district judge in DC. We're awaiting certain rulings. And that case was teed up for trial. We actually took the deposition of Marwan Barghouti in Jerusalem District Court in that case. And then the DC case, we hope will be on a track toward jury trial as well. So we'll have one in New York, potentially one in DC. We're sure the PA and the PLO are going to fight tooth and nail to try to continue to evade liability in spite of the acts of Congress. I thought that might be relevant and helpful here.
It's very helpful to pull this together. As I said, I am just getting through the first, what page am I on? 25 of the brief. Someone asked my question a little bit better, which was, what about challenging UNRWA's USA tax exempt status? I mean, it's dependent upon the goodwill of the IRS. There's a state element there. But before you answer that, I want to throw something else into the mix. AAJLJ on a related atrocity has submitted amicus briefs in Holocaust restitution cases. And among the biggest challenges is State Department jumps up and says, no, you can't do this. We are getting along very well with X country and things like that. In the short time that you file this, are you hearing noises about a U.S. department or agency that has, been telling you we're going to fight this tooth and nail, putting aside the defendants? And I'm curious as to which law firms represent them. That's my question.
We anticipate that the Department of Justice under Attorney General Bondi will be consistent relating to our case in DC with the statement of interest filed by the Trump administration in the New York action.
In April.
Yeah,
Right?
that
Okay.
case is in New York is teed up for decision. Nobody knows what the judge will decide or when she will decide.
Okay.
But in any event, we have not heard anything from the government thus far. The documents are out for service now on UNRWA and UNRWA USA. We'll see how that plays out. You mentioned the State Department. Let's talk briefly about foreign governments. I can tell you that our firm and other firms who have obtained judgments for clients over the last 20 some years have taken steps to try to collect overseas. Most foreign ministries say you're interfering with our relations with Iran or with Libya or now with Syria. And we're going to have to wait and see, by the way, what's going to happen with Syria. Keep your eye, as Joe mentioned, on the fact that while Libya came off the State Department list and paid victims, Sudan came off and paid some monies to victims. There are press reports just in the last few hours, quotes from Senator Lindsey Graham about the question of Syria coming off the State Department list. If they come off, they'll be given their immunity back. What will happen to all the billions of dollars of judgments that we and other firms have against Syria? Issues to be discussed on another day, but we're interfacing here on the one hand with national security, but on the other hand with the U.S. Foreign policy. You mentioned tax-exempt organizations. I'll boot that over, and their tax status. I'll boot that over to Joe.
Well, absolutely, any tax-exempt organization that we bring a lawsuit on behalf of our, hundreds of clients, we do take the position that they do not deserve to be raising money in America. What we do, the element that we bring to them is trying to hold them accountable for their role in the sponsorship and support of terrorism and hold them economically accountable as well. So we certainly are supportive of any efforts that may be undertaken to challenge the tax exempt status of these organizations, and any information or research that we can contribute to anybody who's working on all of that, please do reach out to us, because ultimately, as Richard said, this is we can't afford not to work together. Those who seek to demonize and slander and delegitimize Israel, they work together, it seems like, swimmingly and effortlessly, and we have to be able to get out of our own way and do the same in support of our community.
Very good point. We're down to a couple of minutes, so let me see if I can consolidate something. My understanding is UNICEF has not been particularly useful regarding this issue. Is it the same category as UNRWA? And is there any leverage there? I mean, that's why, I just remember, the little orange boxes from Halloween, right? When I was a kid, I thought that they ripped that off from the JNF, light blue boxes, but that's another story. In other words, they've been problematic now. Does that fit into any of this conversation, or that's not something that helps?
It wouldn't meet our standards for bringing a case
Okay.
at all. Both the United States and Israel remain member states of the family of nations at the United Nations.
Okay.
The UN does lots of things, some good, some bad. Their world courts have been atrocious toward Israel, both the ICJ as well as the ICC. Everybody knows about it. But there's a lot more coming, we fear. And lastly, you ought to think about the fact that it was back in the 1970s when Zionism equals racism was adopted. And here, what we're facing today is no different. There's a revival, and everybody's getting away with it under the umbrella of free speech. And in our view, free speech should not be allowed where it's hate speech, where it's indoctrination, where it's teaching, where it's encouraging, where it's radicalizing, where it's discriminating. And we all have to be creative in finding appropriate causes of action, not just federal, but also state causes of action to bring these matters as deterrents. I'll give Joe the last word.
Just to sort of add to Richard's points on that question that you asked, all of which I agreed with. You know, the UN has gone too far, and there's certainly too many arms and tentacles of the UN that are causing so many different problems around the world. UNRWA is one that has caused direct violence and has participated in direct acts of murder and maiming and rape and hostage taking. And we see them as the most important target to go after. We hope if we obviously care very deeply and want our case to be successful and to set precedent, whether any other entity that dons the UN name can have their immunities challenged, we of course support that. There's a very fact-specific inquiry, and if you look at the Trump reversal letter, you'll see that. You'll see all of the little technical aspects that go into this inquiry as to whether an entity that brandishes the UN logo is actually a UN subsidiary organ or a UN organ that is worthy of protection under the CPI-UN. So this is an important precedent-setting case. The cases that have come before us have not been successful when it comes to suing entities affiliated with the UN, and it's time to really take a look at what the UN is and challenge it any way that's possible.
Thank you. Turning it back to Alyssa.
Thank you so much to Joseph and Richard. That was really enlightening, and this is really groundbreaking litigation. I do want to also mention, as we close out, that Richard Heideman will be a recipient of the 2025 Pursuit of Justice Award. So congratulations, and very, very well deserved. And that is going to be December 4th in Washington, D.C. You will all get more information on that soon, but please mark your calendars. And Richard will be receiving the Pursuit of Justice Award with Dr. Deborah Lipstadt and with Lee Wolosky of Wilkie Farr and Gallagher. So we're very excited for Richard and to have a wonderful event. And again, thank you for joining us today. And as we conclude, I want to take a moment to wish everyone a Shana Tova and a very happy and healthy new year. We're certainly hoping for better times ahead, and may the coming year be one of peace, purpose, good deeds, and justice for all of us, and certainly for the Jewish people. Thank you, and please join the AAJLJ and help us continue our work. Have a good day, everybody, and again, Happy New Year. And take care of yourselves. Bye-bye.
Thank you.
Bye-bye.
This was terrific.
Shana tova.
Thank you.
Thank
Shana
you.
tova.
Shana tova.
Shana tova and mituka.
Yes, thank you.
Israel.